Thanks everyone for being here, and thanks to the folks online as well. We are in for of the Supreme Court's recent decision. My name is Patty Zettler. I'm an associate professor here at the Ohio State University Moritz College of Law and a member of Ohio State's Drug Enforcement and Policy Center. I will be moderating today's session. I'm going to very briefly introduce each of our deeply expert presenters and then turn the floor over to them. Each panelist will talk for about 8 to 10 minutes, and then we'll have time for questions from you all. So you folks in the room, for the folks who are online, you can type your questions into the Q&A on Zoom as we're going. I'm looking at my laptop so that I can see the Q&A in Zoom and see the speakers without having to turn around. So I'm not multitasking. All right, so accomplishments are far too extensive to do justice to in any sort of reasonable amount of time. So again, I'll introduce them briefly. First, Professor Doug Berman, who probably needs very little introduction in this audience, but Professor Berman is the Newton D. Baker and Hospital here at Ohio State, and executive director of the Drug Enforcement and Policy Center. His principal areas of research and teaching are in criminal law and criminal sentencing. Professor Jen Oliva. Professor Oliva is a professor of law at UC Hastings in San Francisco, a senior scholar at Georgetown Law's O'Neill Institute for National and Global Health Law, and a member of the Science and Policy Advisory Council of the National Pain Advocacy Center. Her principal areas of research and teaching include health law and privacy law. And along with Professor Gillespie, she wrote an amicus brief in the case we'll be talking about today. And so that's a nice transition. Third, we'll hear from Professor Kelly Gillespie, who's a professor of law and the director of the health law program at Creighton University School of Law. Her primary areas of research and teaching include health law and bioethics. In addition to her legal expertise, she previously practiced as a nurse and has a doctorate in healthcare ethics. And as I mentioned with Professor Oliva, she wrote an amicus brief in the case we'll be discussing today. And last but certainly not least, we are fortunate to be joined by Dr. Marty Freed. Dr. Freed is an assistant professor in the Division of General Internal Medicine here at Ohio State's College of Medicine. His expertise includes the integration of comprehensive primary care and outpatient addiction medicine. And among other things, he studies how to best treat patients with opioid use disorders within primary care clinics and maintain those patients within treatment. All right, so thanks to our panelists for being here. As a reminder, 8 to 10 minutes for your first remarks, and then we'll open the Professor Berman, I will let you kick us off.
Thank you so much, Professor Zettler. Thank you to the whole DEPC staff for helping us to put this somewhat challenging but somewhat exhilarating hybrid event together. Thanks to all of our panelists as well. I'm so excited to hear from everybody. I'm going to give you about a 6 to 8 minutes kind of overview from a criminal law perspective, because it was a criminal law case, this case from the Supreme Court last term, Ruan versus United States, which really created the foundation for us putting a panel together to not just talk about, how the criminal law has approached the opiate epidemic, but how health law and doctors are thinking about these issues that the criminal law was sort of the first frontier for through the Ruan case. And one of many things that I think is interesting about the Ruan case is we hear lots of talk these days, I think in some sense rightly so, about a deeply divided and very conservative Supreme Court. But I think that talk looks a little different when you look at Ruan, because it's a case in which the justices voted unanimously, 9-0, to reverse the conviction of 2 defendants who had been convicted by juries of drug trafficking under the Federal Controlled Substances Act. Now, these were unusual drug defendants. They were doctors, though I also think it would not be impolite. Certainly some others called them pill mill doctors, and that's how the criminal justice system came to care about what they were doing. The trial evidence, which was a little bit debated, but kind of highlights from the 2 cases that got to the Supreme Court, one involving Dr. Ruan. His clinic issued over 300,000 prescriptions for various opioids over just a few years. And Dr. Ruan had a financial interest in many of the drugs that were being prescribed out of his clinic. Dr. Khan, who was a defendant in another case that was a companion in front of the Supreme Court, He actually and his office often sold prescription opioids for cash, even firearms, sometimes in the parking lot, some of the evidence suggested, and he did it without performing traditional exams, and there was falsified paperwork according to the government. Still, these doctors claimed they were prescribing drugs as part of legitimate medical practice. And at issue before the Supreme Court was what the jury instructions should be in a prosecution of doctors. What was the right, proper description of the standard for criminal liability? The Controlled Substances Act criminalizes knowingly or intentionally distributing controlled substances, quote, except as authorized. And of course, one authorized exception is for a registered doctor to dispense controlled substances for, quote, a legitimate medical purpose in the usual course of professional practice. So that's what the issue was up. They were claiming we were still part of this authorized exception to distribute drugs for a legitimate medical purpose in the usual course of professional practice. At trial, what was so interesting and what teed up the issue for the Supreme Court was trial courts had interpreted that to mean they should instruct juries. If the doctors failed to live up to an objective standard of legitimate medical purpose, then they could convict them as drug dealers under the Controlled Substances Act. In other words, the juries were told if reasonable doctors wouldn't have prescribed under these kinds of conditions, then these doctors could be convicted, should be convicted criminally because they didn't live up to an objective standard of reasonable medical practice. The doctors asserted, lost in the lower courts, but they reasserted this now as the case got to the Supreme Court, that as long as the doctor subjectively believed that they were practicing medicine, if it was their subjective intent to still be doctors in a sense, then they couldn't be convicted under the statute. And they claimed at all times they believed in good faith that they were prescribing for legitimate medical purposes and so should not be criminally liable under that applicable statute. And lower courts had actually divided about whether the doctor's subjective beliefs were key or whether this objective standard was central. And most of the lower courts had said, no, we think the right approach is if it's objectively unreasonable and a jury finds it was objectively unreasonable to prescribe under these circumstances, then a conviction was proper. As this got to the Supreme Court, you won't be surprised about the public policy issues I think we're going to be talking about here for the next hour or so, were presented to the justices. The government emphasized the opiate overdose deaths and epidemic, the broad harms of opiate overprescriptions, trying to encourage the court to adopt this objective standard, this idea that the doctors had to practice reasonably in a sense. But the doctors and many amici, and of course we heard there was an amicus brief was filed by two of our panelists, emphasize another policy concern, namely that an objective standard could deter reasonable and responsible doctors from ever trying any novel medical therapies that had not been accepted by traditional medical practice. You would dissuade doctors from ever taking a chance, you might say, if there was going to be this constant threat of criminal prosecution, because a jury, what does a jury know? A jury might deem that unreasonable practice at a prosecutor's behest. Interestingly, these policy issues didn't really infuse what the Supreme Court did. The Supreme Court really treated this like a traditional criminal case, focusing on the text of the statute and mens rea issues. But Justice Breyer, one of his last opinions for the court before he retired, he really stressed not just only this importance of mens rea to criminal liability and this longstanding presumption of requiring a defendant to have a culpable mental state as a reason for adopting the subjective standard. But Justice Breyer also stressed that we expect, this is his quote, we expect and indeed usually want doctors to prescribe the medications that their patients need. So clearly influenced by this concern about over-deterrence, this worry that an objective standard might prevent doctors from doing the kind of medical practice that they thought was essential. And he went on to say, it's essential to separate physicians' socially beneficial conduct from criminal conduct. And the best way to do that would be to require proof of a subjective intent to not act as doctors, to put it in those sorts of terms. So the bottom line was that all the justices agreed that the subjective standard, not an objective standard, was the key to apply to doctors charged with violations of the Controlled Substances Act. And Justice Alito wrote a little concurrence that emphasized that he thought the doctor should have to prove that they had the right intent rather than the prosecution having to disprove that intent. But he really put this, I think, in the best way. His quote was, "A doctor who makes negligent or even reckless mistakes in prescribing drugs is still, quote, acting like a doctor. He or she is simply acting as a bad doctor. We don't want to prosecute criminally just bad doctors. The same cannot be said," he goes on to say, "when a doctor knowingly or purposely issues a prescription to facilitate addiction and recreational abuse." And so all the justices agreed with this idea. We want to try to sort out who are the good doctors, or at least the doctors trying to be doctors, even if they might be negligent or reckless, from the true criminal actors. And so going forward, and there was actually an article just earlier this week in CBS News highlighting that a bunch of doctors who had been prosecuted under the objective standard are now having their cases reconsidered under this new Ruan standard. And it's very clear that juries will be asked to scrutinize, and prosecutors will have to think about whether they can prove to juries whether the physicians charged actually believed their behavior was legitimate, rather than assessing guilt based on some objective, reasonable standard of some hypothetical, reasonable physician. This doesn't mean, and important last point as I wrap up, that doctors can never be subject to criminal liability. And in fact, Justice Breyer went out of his way to say circumstantial evidence might show how clear it was, perhaps trading firearms in a parking lot, that a doctor subjectively knew he was not practicing medicine, but actually just facilitating misuse of drugs. But Ruan ultimately makes clear that the jury's inquiry for ascribing criminal liability is the doctor's subjective belief, not some objective standard of medical practice. And I think rightly so, the opinion's been hailed as a victory for physicians, considering innovative treatments, and should assuage concerns about unduly chilling, I might say, real doctors from prescribing needed pain treatments and others. And I think more broadly, what to me as a criminal law professor and seeing some of my students, thanks for coming, to sort of highlight this point, is that even in the midst of a historic opiate crisis, even at a time when there's probably quite rightly widespread concern and anxiety about what we can do, what more we can do to try to deal with the problems of the opiate epidemic, and even with a very conservative and often very fractured Supreme Court, the justices found common ground in these longstanding norms of criminal law, this core principle of mens rea as central to criminal liability. And in that respect, I'm going to keep citing Ruan in the work that I do, because it stands for a lot, even outside the healthcare field. But now we get to hear from some healthcare experts about what it means to them.
Well, thank you, Professor Berman, for that summary of the case and its import for criminal law. I'm sorry, I can't remember, Kelly, or are you next or is Jen next?
Yeah, I think I was going to go next if that still works. All right. Well, as Patty mentioned earlier, I am Kelly Deneen Gillespie, and I want to thank everybody involved in this, and thanks to Ohio State and everybody involved for inviting me along with Jen to talk about this case. Just to pick up on Doug's points here, I think it's really important as a preliminary matter to acknowledge that I think neither one of us, certainly I can speak for myself, are passing judgment about whether Dr. Ruan or Dr. Khan were good doctors, negligent doctors, reckless, or even, really involved in criminal enterprises. That the government argued facts a lot. And, there's an old saying, when the law is on your side, you argue the law, right? And when the law is not on your side, you argue the facts, right? Which was kind of the approach that was taken. But this really was a question of what the appropriate legal standard, what the interpretation of the statute was. I also want to say that I will say some things in the course of this conference that may raise concerns by people. I want to say I am not saying there wasn't injudicious prescribing at times. I also am not saying that there aren't, in fact, quote unquote pill mill doctors. I do assert that the number of physicians and other prescribers who have been investigated and and prosecuted under Section 841A1 exceeds those numbers, right? And it's important to remember that prescribing any drug, right, is ordinary, reasonable, and expected part of everyday medical practice. The same is true with controlled substances. The label of controlled substance imbues nothing magical, right? And drugs that are both controlled substances or not controlled substances pose the potential for risk and benefit to the patient, right? But only when it comes to prescribing controlled substances do doctors and other prescribers inhabit this very, very perilous space where one course of conduct can give rise to can feel like an unending number of legal remedies, right? And this federal felony drug distribution, punishable by $1 million fine and up to life in prison for each offense, is the harshest of all penalties. And it really ought to be reserved for those truly engaged in a criminal enterprise. That for doctors who are careless, mistaken, right, reckless, overworked, who violate technical requirements about prescribing, those doctors are best dealt with through civil and administrative remedies like state medical boards, perhaps actions in torts, right? The federal government has the power to take away their potential to ever write a controlled substance prescription again, right? We have lots of legal tools to make sure these practitioners never touch a patient for the rest of their life, short of spending their life in prison, okay? I also want to say that the way that the circuit's standards have eroded, particularly since the rising public awareness about the so-called opioid crisis, which is better described as a drug poisoning series of crises, especially after 2013, is rightly described as that the public response, I think, is fairly described as a moral panic, not because there's not a serious public health problem from drug poisoning and other harms related to drug use, right? But because public policy anchored so quickly on prescribed opioids and then anchored very quickly on prescribed opioids for people in chronic pain. And the evidence continues to emerge, right? That in fact, those were not the primary offenders in this drug overdose crisis. And moreover, often supply-sided interventions occurred focused just on reducing the prescriptions of controlled substances, in particular opioids, alone, not paired with any concerns about how we treat patients for whom we may have concerns about their drug use, how we appropriately provide care for people with chronic and persistent pain, people who have substance use disorders, including opioid use disorders, and for patients that have both, which is a subset of patients, although the numbers of people with chronic pain believed to have opioid use disorders is widely over-exaggerated by a lot of people in the public. So we've got this history of not well-tailored drug policy. We have this history of criminalizing not only the patients most in need of care, but also the physicians and other providers that are still willing to help them. And this overzealous pursuit of these efforts does, and we know this historically, we've known this for at least 100 years, if not more, in this country, but we have like sort of a collective amnesia and a collective insanity in drug policy in the United States. We just keep doing the same thing over and over and expect a different result, right? And so the circuits had eroded the standard sort of in line with what you would expect, that we're just going to keep doing things that don't work, right? Had eroded the standards to the point where it wasn't just innovative doctors, right? Actually, and Jen will talk about this more, it was doctors who were doing things that they thought were in the best interest of their patient, right? Things that would have been solidly considered within the standard of care, who faced investigation. And also we neglected the deterrent effects, the over deterrent effects, and the over compliance effects of law and policy, such that we were at a point, you know, in many ways we're still here, but hopefully this decision is one small step in improving patients' lots in this regard. Is that we have created the incentives for doctors to abandon a patient outright, even patients, just patients that they associate with opioids, whether or not those patients need or want it. And so we have, instead of improving access to care and treatment for people in need of care, including care with controlled substance prescriptions, we have created an environment that further drives them away from medicine and into the shadows, which is ultimately more harmful. And so today we sit with the lowest rate of prescribed opioids and controlled substances since the 90s, and continuing the highest overdose rate in history. And so with that, I'm going to turn it over to Jen, who's going to talk about the federalism reasons and some of the really important things to consider about the evidentiary standards for the standard of care in these cases.
Thanks so much, Kelly. Thank you to Professor Berman, Professor Zettler, my distinguished co-panelists, the entire excellent DEPC staff for having me here today. I also want to thank some of my chronic pain patient friends and my friends, the National Pain Council, who persuaded me to get involved in this work, for attending today. And they've worked so hard to help me understand what they've experienced. I'm delighted to be on this panel. So we opened our merits brief in the Ruan case with a discussion about the appropriate reading of Section 841 scienter requirement, or mens rea requirement, which Professor Berman covered with panache. We followed it by a terrific section about how the court's construction of that section, which effectively converts this criminal felony law into a mere negligence standard, significantly impacts prescribers, innovation in the practice of medicine, and of course, patients, which Professor Deneen Gillespie wrote and just expertly summarized. She was kind enough to allow me to make two additional arguments in the brief that I'm going to quickly summarize. First, we advanced a federalism argument. Specifically, we contended that any construction of Section 841, which again is a federal criminal law, that criminalizes mere medical error improperly intrudes on the state's power to regulate the practice of medicine. Now, in our federal system, it has always been the case that it is the states and not the federal government that has the primary authority to regulate the practice of medicine under their reserved police powers in the 10th Amendment to the United States Constitution. The federal courts that have addressed the issue, including the United States Supreme Court, have reiterated and reaffirmed this basic federalism proposition time and time again over the last century. And for the avid readers out there, I made every effort to cite those cases in the brief. Bolstering our argument here that insofar as the federal government was now criminalizing mere medical mistakes, and it has therefore overstepped its constitutional authority, we pointed to another longstanding and pertinent canon of construction that has been embraced by the Supreme Court, which is the clear statement rule. The federal courts have long held that the federal government has no right to interfere or otherwise preempt states in the exercise of one of their quotes unquote clear functions, like their authority to regulate the practice of medicine, without a clear indication or statement from Congress that Congress intended that result. In other words, the thrust of the argument from us was that unless and until the federal government can point to plain language in the Controlled Substances Act that makes it clear that Congress conferred or delegated to the Department of Justice the authority to usurp the states by criminalizing good faith medical mistakes, the clear statement canon forecloses the 11th Circuit's construction of Section 841. Legal scholars like William Eskridge and Philip Fricke have characterized the clear statement canon as a super strong rule of statutory construction in this context, and that simply means that it carries a weightier force than ordinary preemption rules. As it turns out, not only does the Controlled Substance Act not contain any clear preemptive statement, it very clearly leaves to the states the authority to regulate the practice of medicine. Specifically, the Act states on its face, and I'm quoting here, quotes, nothing in the Controlled Substance Act's regulations or guidelines may authorize any federal official or employee to exercise supervision or control over the practice of medicine or the manner in which medical services are provided. Moreover, the Supreme Court expressly relied on this particular provision of the Controlled Substance Act and the clear statement canon in its 2000 decision in Gonzalez versus Oregon. And that's a case in which the court held that the federal government had no authority under the Controlled Substance Act to regulate physician-assisted suicide in Oregon, as that medical matter was historically entrusted to the states. In Gonzalez, the court explained, and I again going to quote, the Controlled Substance Act and our case law amply supports the conclusion that Congress regulates medical practice insofar as it bars doctors from using their prescription writing powers as a means to engage in illicit drug dealing and trafficking as conventionally understood. And the court goes on in great length to explain that the regulation of the practice of medicine is reserved to the states. So longstanding and even quite recent precedent strongly supported our federalism claim. But even more important, in my view, is the practical realities of the federal-state regulatory divides in this context in a critical area of expertise. Under state law, the regulation of the practice of medicine is conducted in basically two fora, which Professor Gillespie just explained to you. One, before state boards of medical practice, which are composed of medical doctors in all jurisdictions who are trained and licensed medical experts. And two, and state medical malpractice tort actions that are confined by important expert evidentiary and other rules that do not apply in these federal criminal proceedings. I'm going to get to state medical malpractice and experts in a minute, but first let's reflect on the state boards of medical practice. Here to accept the federal government's premise that it has authority to regulate mere medical error in this context, you not only have to overlook the plain text of the Controlled Substance Act and 50 years of precedent, you have to somehow reach the conclusion that the United States Congress created a scheme that permitted a federal law enforcement agency staffed by drug interdiction police officers with zero medical training or expertise to perform a function that is conducted exclusively by trained medical experts in the states. That's simply strange credulity. The final point that I want to make today brings us back to the state medical malpractice actions. In closing our brief, we argued that the 11th Circuit's construction of Section 841 established a standard for the government to criminally convict a prescriber that was lower than the applicable state standard for civil malpractice liability. And that's for at least two reasons. And as a reminder here, Dr. Ruan's practice was in Alabama, a state whose medical malpractice laws are fairly typical of other jurisdictions. I did an investigation. First, plaintiffs in Alabama's civil malpractice actions are required to prove that they were harmed due to their prescriber's negligence. I assume that most of the folks here took first-year torts, a course that I'm privileged to teach, and know that the four elements of a negligence claim are duty, breach, causation, and damages. In other words, if you've not been harmed by a good faith medical error, you have no claim under state law. Under Section 841 of the CSA, on the other hand, the federal government does not have to prove that the prescriber's conduct harmed a single patient to convict the prescriber of felony drug distribution. Second, it's far easier for the government to actually prove that a prescriber departed from the quotes unquote usual course of professional practice under Section 841 in the federal criminal statute, then prove that the prescriber deviated from a state standard of care that's usually applicable in state torts actions. This is because state tort plaintiffs are only permitted to use a narrow set of experts that have the same or similar specialties, training, and expertise that were involved in or implicated in the alleged underlying malpractice at issue. These criminal CSA cases, on the other hand, revolve around an amorphous national standard of practice and lack any requirements regarding the testifying experts' specialties, training, or expertise. I took a hard look at the experts that testified on behalf of the government in Dr. Ruan's trial, and virtually none of them would have even been permitted to get on the stand to testify on behalf of plaintiffs in an Alabama medical malpractice action based on the same conduct as was involved in Dr. Ruan's criminal case due to their lack of pertinent experience and expertise. So we wrapped up our brief with this dramatic banger. We contended that Dr. Ruan's argument that the 11th Circuit's construction of the CSA based on nothing worse than simple malpractice was actually too generous to the government. Instead, we argued the 11th Circuit's construction made it easier for the federal government to criminally convict doctors for felony drug distribution than it would be for a state plaintiff to succeed in a civil malpractice case based on the exact same conduct. I'm going to turn it back over to you, Patty.
All right, well, thank you so much, Professor Oliva. That was great. And so yeah, last but certainly not least, we have Dr. Freed sharing his clinical perspective.
Thank you. I appreciate getting a chance to come over here. This is certainly a change of environment for me. In my clinical primary care doctor, academic primary care doctor at the medical center, my clinical interest, as Professor Zeller pointed out, is the integration of addiction medicine into primary care. Because a lot of the medicines that we use to treat substance use disorders, specifically opiate use disorder, are opiates themselves. I get a lot of referrals from colleagues with complicated pain management cases, specifically opioid cases. And the other reason why I get a lot of referrals is because my colleagues don't want to do this. And they don't want to do it for a lot of reasons, some of which were articulated by Professor Gillespie, but there is this perceived notion of like legal culpability when you're engaging in this practice. This was born out. Professor Zettler and I are about to, like, hopefully this week, submit a paper that we interviewed a whole bunch of primary care doctors, and this came up over and over again. And interestingly, like legal ramifications, like to what degree and from who was like conspicuously absent, but there's this like perceived like, notion out there that they're like, liable. And I think this really matters like to the implications of the Ruan decision, because it, this idea of like good faith prescribing, I think is something that we're still kind of figuring out what that means. Use my time just to like tell you about how I think about good faith prescribing. It's like informed by not only my own like experience, but also like guidance from experts across the country and education. I think about good faith prescribing in three kind of phases. There's the initiation of these medications, there's the maintenance of these medications, and there's the termination of these medications when that calls for. And to do that, I'm going to tell you an anonymized story of one of my patients. To drive that home, we're going to call him Brandon. So I met, so Brandon is this is one of my patients. He has a history of cirrhosis from drinking too much alcohol. He is kind of like a rough around the edges guy, worked for most of his career with getting, odd jobs around his community. And Brandon's story actually started before I met him, when he was hospitalized for a really severe illness and was discharged under hospice designation. And so you guys probably are familiar with hospice, and hospice means like you're at the end of your life. And so we aggressively palliate symptoms. And a lot of that is the management of pain. And so when he was discharged from the hospital, he was prescribed high doses of multiple opiates for the pain that he was experiencing, as well as benzodiazepines. This is all borne out in the state controlled substances record, the physician drug monitoring program, so it's like, this is a true story. And he was on hospice for like several weeks, which turned into several months. And the hospice providers eventually said, Brandon, the good news is you're not dying. The bad news is like, we can't continue to treat you anymore. So, buena suerte, good luck. And, go out there. And so he shows up in my clinic, you know, like uncomfortable, having been treated for months on these, you know, legitimately prescribed medications for a legitimate indication at the time. And he was in pain. He kept on using the words dope sick. And so I initially treated him as one of my substance use patients. So I prescribed him a medication called Suboxone, which is an opioid, but it's a little bit safer because it doesn't fully activate the receptor. It kind of it's hard to overdose because it only partially activates the receptor. And he agreed, and we also talked about, all right, like how are we going to like comprehensively manage your pain? Or like, you know, what are the active therapies? What are the non-opiate, non-pharmacologic therapies we're going to prescribe? And so that's like the kind of some of the principles of this like good faith initiation of opiates is that we don't really necessarily start with opiates first. There's some steps before we get there to make sure that like this is a, you know, pain that, or circumstance that rises to like the level of needing like these kind of, we think about like big, you know, big therapies. And he played along, and very quickly it was obvious like we weren't making any headway into like addressing his symptoms. And that's like another piece of this initiation is that we started with these like functional goals. You don't really think about pain management as like a scale of 1 to 10, but we like set out like, all right, can we get you back to work? Can we get you to engage in meaningful activities with your family? And when that we weren't hitting that with Brandon, we said, okay, it's time to like do what we call full agonist or oxycodone. And Brandon did really well. He felt better. He got involved in GI and gastroenterology, liver docs, and we treated his Hep C, which was like an amazing like accomplishment. You know, engaging him on this level was within primary care was able to like address many other like health issues that would have otherwise been neglected. I ended up seeing like his daughter, his son-in-law, his niece, like his daughter just had a liver transplant down the street. So there's like ripples of like engaging with Brandon on this level. So we really saw like tremendous benefits from not only Brandon, but also like his community. And part of this maintenance, so now we're kind of like, so we started it, now we're like, how do we safely prescribe over a long term period of time? Some of that involves just urine drug screens, just a whole another discussion, but just like how do we delicately, you know, not play a doctor and not a police officer. And for a while, those were consistent with the medications we were prescribing. And the benefits were clearly outweighing the risks for this patient at this time. And then the pandemic hit. And you guys are probably aware. And we just, it was hard to keep track of folks, especially folks like Brandon, right? He like doesn't have like a lot of the things that we just like take for granted. And so, you know, it was hard to keep track of him. He was not necessarily showing up for appointments. Certainly the urine drug screen monitoring was like much more difficult. And there was a time I was like, let's keep you safe, right? Like, but eventually I started learning through his family members that like Brandon wasn't doing well. And there was some concern that he was diverting his medicines and drinking again. And it was at that point where the balance of benefit versus risk was probably tipping in the other direction. And so we talked about it. I talked about it over a long period of time with Brandon and my concern. And eventually we got to the point where like, you know, Brandon, we can't continue this anymore. And so when that happens, you know, like, especially within primary care, which is like a wonderful place to be, like, I get to like separate those two. And I said, like, Brandon, we're going to like move on from these medicines, but I'm always going to be your doctor. We're going to, you know, like health issues and other concerns, like we're going to keep that because that's really important for both of us. But like, this is not working anymore like it was. There are alternatives which you can take or leave, but and like, for what it's worth, you know, he didn't necessarily disagree. Like we had a frank discussion, like what was happening to those like pills. And so I think that's like a really important piece of this is like, you know, in this good faith prescribing is like, how do you like respectfully, but also assertively like stop a therapy when it's happening? As you know, Professor Gillespie pointed out, like we do this all the time with like insulin, right? And that's never like a charged discussion, you know, when like, you know, it's not working out anymore. But it's kind of harder when all of a sudden now we're dealing with like controlled substances and the gravity of that. And so I think like coming back to like the implications of Ruan, I really thinking about like the concerns that my colleagues had in the paper that I mentioned that Professor Zettler and I are working on, like I hope that some of those are assuaged by this decision. There's other like levels of responsibility and you know actors that we have to like are accountable for, and that's probably makes more sense because we're speaking at least the same language. And so I'm hopeful that this will be allow more patients to get comprehensive pain management with these medications.
Only use your moderator's prerogative to talk about your paper if you want.
No, I'm not gonna, well, thank you all. Thank you all for those comments. So now we have time for questions. We already have one question in the Q&A from the folks online. So online folks, keep typing your questions in. I'm going to ask one question while you all think about it, and then you can and ask your questions as well. And so Professor Berman and I are law professors, so if you really test us, we might just ask you for your question. A sort of health law related question. As Professor Berman highlighted in his opening comments, the interpretation case about the Federal Controlled Substances Act. But the phenomenon of criminalizing aspects of healthcare is not necessarily specific to this statute or to prescribing of controlled substances. And in particular, right, since the Supreme Court overturned Roe v. Wade in June of this year, we've heard quite a bit about states imposing criminal penalties care and lots of fear among medical professionals with respect to taking care of patients in the reproductive health context. So I guess I just want to pose to the panel whether there are parallels that any of you see between group contexts and other areas of healthcare. Gillespie maybe wants to kick us off, so I'll turn it over to you.
Sure. I'll jump in a little bit. But also, I just wanted to let you know, at least for me, Patty, your question was the mic was breaking up a lot. So I'm just going to repeat what I think the question was, which was the criminalization of, I'm not going to say it as well, but what implications does Ruan and like the criminalization of patient care, like what implications does that have more broadly, especially in light of Roe versus Wade being overturned? Is that correct? Okay. So I would just say generally, and I believe it was Doug Berman who said this, that whenever the law tries to invade medical care, it doesn't go well. Something like that. I'm paraphrasing, but something like that.
Brilliant. So I must have said it. Yeah, sure. Okay.
Yes. So, and I think generally the criminal law is too blunt an instrument for the nuances of clinical care. And I think that we can't stress enough the perceptions of criminalization, right? Because anytime we criminalize people or conduct, it is state sanctioned stigma. And, we make choices about that as a society, right? But particularly in the area of drug use, right? We have state sanctioned stigmatization of people who have use disorders. But the impact of the fear of criminalization, right, is such a powerful driver of behavior and we've seen this in the news stories in the aftermath of the Dobbs decision in terms of the perceptions in states that, now have laws on the books that criminalize the provision of reproductive services in certain circumstances, we have seen the perception drive the abandonment of patients in need of care. And sort of folks will say, well, that's not actually what the law says. The law doesn't prohibit this procedure in this context. But the point is, it doesn't really matter, because beliefs about what the law says, right, and beliefs about what kinds of behavior that would otherwise be socially desirable, but certainly not unlawful, beliefs that those things will be criminalized, drive practitioners away from patients desperately in need of care and treatment. And this is a serious concern. And then we drive folks out of the medical realm altogether and into a place where far more harms tend to result.
I'll just pile on there and say that, and this is going to sound somewhat critical, so I'll just go ahead and disclaim that I'm adamantly pro-autonomy, pro-choice, and pro-reproductive justice here. But many of the issues that we've raised over the years in drug policy are now sort of like coming to the fore here with the sort of post-op setting, and they're getting a lot more attention, and that's great for everybody. But what they have been raised in the past. So the first big sort of parallel that I see is that we often get bad law and policy and these sort of complex arenas of medical practice where even medical experts, right, have to make tough decisions that are maybe poorly understood. So even experts will admit that, the sort of causes of drug use disorder, the causes of chronic and persistent pain, and these other conditions is complex and hard to pin down. The other thing is, of course, the parallel there is that most people, policymakers, et cetera, don't seem to have a good understanding about how risky pregnancy often is for people who are pregnant, nor how often pregnancies are unsuccessful and result in miscarriages and births. It's estimated that nearly 1 in 4 pregnancies come to a conclusion that way, unfortunately, in the United States. The debate always centers around, unwanted pregnancies, and that kind of stuff, but it never really kind of centers around the fact that, we have a really high percentage of pregnancies that are going to be very complex and complicated in the normal course of a wanted carry. So the medical interventions that are required to protect and save pregnant persons in these circumstances often demand abortion-related health care, and that's now entirely unavailable in most instances in numerous states. So I guess the first parallel is I just see, again, policymakers and the public sort of getting on bandwagons around certain kinds of laws and regulations, whether they involve chronic pain, opioid use disorder, pregnancy, they're likely to enact harm and exacerbate already unfortunate and complex medical decisions. The second parallel for me, of course, that I'm going to complain about is about health data privacy in the surveillance space. So like I've made a fuss for years, as have numerous other people, about the hyper surveillance of drug use. And this has actually been particularly targeted at pregnant women who've used drugs. Hospitals routinely drug test pregnant women they suspect of drug use during pregnancy without their consent, and frequently report the results of those tests to law enforcement and child protective service agencies, which instigates a cascade of potentially harmful outcomes for that family. And again, we've complained about this for years, and now you've saw post-Dobbs a number of organizations, rightfully so, trying to explain to folks how to protect themselves from the period apps out there and all the apps that are out there, and state and federal surveillance. So to me, those are two big connections. And I guess the last two I'll just mention real brief are health equity, which is that it always is the same folks that overpay or over-targeted in these arenas. And again, poor pregnant women in both arenas is just one example. Chronic and persistent pain patients are more likely to be middle-aged women and not believed, and on and on and on. But we sort of see marginalized and stigmatized groups, as Kelly mentioned, particularly targeted in this arena. So those are the few things that came to mind for me.
Sharing that. Oh, well,
Up to them now, okay.
I'm supposed to be muted on here. Yeah, sorry. So before we turn to your questions, I do, Dr. Freed, want to give you a chance to weigh in. Professor Gillespie mentioned, you know, it doesn't matter just what the law is, but it also matters how healthcare professionals perceive what the law is or perceive what risk is. And you mentioned this right at the end of your remarks, but I wonder if you have any additional reflections about whether your colleagues are aware of the Ruan decision, what it might take for them to be aware of the decision, or sort of, you know, what this might mean for how comfortable healthcare professionals feel moving forward.
Yeah, that resonated so strongly with me. A really quick story about, or a patient story about another criminalized area and related to this idea of perception, and then I'll get to the second part. Is just, so I do a lot of harm reduction work. Harm reduction is preventing the complications of drug use while you're working on the underlying. And I had a patient this winter who biked to my office in like sub-degree weather, or like 0 weather. And he said, hey, I can't make it to the needle exchange in Columbus. Can you prescribe my syringes? Because he involves, because he did his IV drug use. And like that perception, I was like, I'm like pretty sure that's okay, like, or not overtly like targeted in Ohio, but I know in Pennsylvania it's a problem. I'm like, I'm pretty sure he's staying in state. Like, it's like all these things just like start flooding. So anyway, like that's just that harm reduction. Like it was, that question immediately struck like all the work I do to harm reduction. The Ruan, you know, it's hilarious. I've mentioned this to multiple people. I've announced it to my whole division. It's like 70 docs, and like nobody knows about this. And you know, and like I think they're occupied by other Supreme Court decisions that have been like in the last 6 months. You know, what it's going to take. I mean, it's hard to say. Like is this going to be a reason for folks to prescribe more, or does it take folks prescribing more to appreciate the implications of this decision? I'm not 100% sure. I talk about this ad nauseum with my colleagues, but it's hard. Like, I wish I had an easy answer. It was shocking to me how little like my colleagues knew about this case.
Yeah.
I was wondering how, and this is directed especially towards you, Mr. Berman, you talked about how this is kind of a shift from an objective standard to a subjective standard. Do you think there could be repercussions in the broader legal field? I was thinking of cases like Graham v. Connor, where its use of force is governed by an objective standard.
I would certainly like to imagine a world in which the Supreme Court thinks a little bit harder about its embrace of objective standards versus subjective standards, when particularly we're talking about criminal liability, and there's a variety of settings where we see mens rea kind of echo through there. I do think this is one of those environments in which, you know, not just Justice Breyer writing for the court, but the entire court is in some sense sensitive to the things that we're talking about here, kind of understood that, not that doctors were unfairly singled out in the opiate epidemic environment, but that they particularly saw in this context the crudeness of prosecutors saying, well, here's something we can do. We can go after the doctors also. And I think it's a testament to many of the amici briefs and others that said, not just this is not a great instrument, but it's particularly worrisome that we're going to use a federal criminal law that is fundamentally about illegal drug dealing and apply that to doctors just because we're concerned about how they're going about their practice, right? And so I doubt alone it's going to have broader resonance. I do think it's a really good reminder to those litigating, whether they're criminal cases, whether it's even, you know, malpractice cases or the like, that the Supreme Court has an understanding that whether it's a doctor population, whether it's some other set of actors, this kind of risk of over deterrence, right? This risk of embracing a standard that feels like, hey, we're doing something, we're going after the bad ones, but we're defining who the bad ones are by some sort of generic, you know, less nuanced and not always well understood sort of notion of reasonableness. I think that's where it may echo, right? But again, it's going to depend on the personnel of the court. It's going to depend on, you know, I'd like to even, you know, piggyback off of Professor Zettler's first question. oh, if any of the kind of prosecutions in the wake of Dobbs, find their way, up to higher courts, will they look to Ruan and say, no, this is inappropriate, the doctor thought they were doing healthcare, and so there ought not be a criminal prosecution, even if there ought to be perhaps, licensing concerns or tort concerns or whatever other civil tools we might use. But I think if the political will is, well, no, there we want to go after the doctors, they'll go after the doctors, right? And so, and that's why we have panels like this ultimately to sort of try to echo out these messages, but also see where they might take us. And I'm not super confident the court's prepared to do a real dramatic shift unless the context is just right, which I think this case turned out to be.
Professor Oliva, did you want to weigh in on that also?
I just wanted to say what the right thing is, which is that I agree, which is always the right answer there. But if for the students or anyone who's interested in this, an interesting read at the intersection of criminal law and repo rights are the two recent decisions decided by the Northern District of Texas and the District of Idaho in the EMTALA cases, which sort of kind of decide, by the way, they're split decisions. Idaho enjoins, right, the Idaho criminal abortion statute, and Texas comes out the other way. But the Idaho case in particular, and both cases discuss the effects that these competing laws have on emergency room physicians and the decisions that they have to make in real medical practice in real time. And I found them very interesting. So for folks who are kind of interested in this and sort of jurist views on how these things impact doctor decision-making in real time, I think both of those cases are actually very interesting reads.
I'm going to pose the first question from the Q&A, which I think is a lawyer question. Someone in the Q&A asked about the new CDC opioid draft guidelines. So the Centers for Disease Control and Prevention have guidelines for prescribing opioids. There are new draft guidelines coming out that expand for. And the question is about whether those CDC guidelines can be used to help define what the usual course of medical practice is in terms of understanding what that means under the Federal Controlled Substances Act. So Professor Gillespie and Professor.
Yeah, so I mean, the CDC guidelines, and I'll defer to Professor Gillespie, who's actually also a medical expert on this, but obviously did not incorporate any particular standard of care that was derived either nationally or from the states, and instead set these caps and dosage thresholds in 2016. And I call it the Pirates Code sometimes because the CDC said, hey, look, it's just guidance. It's not the law. We're just trying to provide some, barriers. And what ended up happening was many state legislatures or regulatory agencies ossified or codified those caps and thresholds. And of course, many payers, insurance companies decided to use those as a rule of thumb in making decisions when they were presented with prior authorizations and things like that. So that's problematic. I'll leave that there. We'll see what the CDC is going to do. Kelly and I have great debates about this, but I'm going to turn it over to her to comment further on standard of care.
Yeah, I mean, I agree. And I think, again, it's guidance. It doesn't set the standard of care. The standard of care has to be set, under all of the circumstances as presented at whatever situation the court is looking at. But in terms of real legal standard of care, but again, what they say can and did, we know historically, change the way that insurance companies and state legislatures and state medical boards view what are the edges or boundaries of quote unquote acceptable care, which, I think did ultimately far more harm than good in a lot of ways.
Yeah.
It's one thing I'm kind of wrestling with. Obviously, I'm all supportive of removing medical practice from the criminal context, but doesn't this really let doctors off the hook for like any type of culpability in the opioid crisis? I mean, in the principal case, I mean, obviously he's writing I think 300,000 opioid prescriptions. Whether or not he subjectively believed he was acting as within the scope of his practice, like the issue is like he's still very recklessly prescribing opioids, and a doctor can do that and somebody can deal heroin once or twice and go to jail for a very long time. I just feel like there's kind of like this mismatch in terms of how that's treated.
I will certainly chime in to say there's no doubt, and this was partially what was being emphasized by the government to the Supreme Court, that the subjective standard that's now embraced creates the opportunity for doctors to hide within that if they can, and we have reason to worry they will, try to kind of misuse their license to be, in a sense, drug dealers. At the same time, and I won't speak for our other guests, but the sense is, and I think it's a reasonable sense, we have lots of other tools to go after those folks, right? And in fact, that's where the balance lies is, how effective do we think are state medical boards, tort suits, a range of other regulatory mechanisms, including, of course, state criminal laws, right? And it would be possible. I think it was referenced a little bit. I think it's worth kind of emphasizing here in this context. By virtue of being prosecuted under federal controlled substances law, the amount of their punishment would be judged in part by how many drugs they dealt, right? Well, these are doctors who are dealing with lots of cases. In fact, oftentimes the way federal prosecutors become aware of who to prosecute is they look at patterns of prescribing and say, oh, they just prescribed a lot. All right, let's look into what they're doing and seeing if it's fishy. And so these doctors were subject not to the kind of punishment dealing 1 or 2 doses of heroin would involve. They both got over 25 years and probably only got less than life because they were doctors, and the sentencing judges took that into account. And so I actually think there's a space to address the concerns that you have, although I'd love to hear the more expert folks here on the doctor side of things see, maybe state law should fit in here and have some kind of more minor, but still not insignificant criminal sanction for a certain type of misprescribing that would enable state authorities to be attentive to this in a way that maybe state medical boards. I know there's always allegations that state medical boards protect their own and things like that. And so I think the nature of your concern in many respects was exactly what drove federal prosecutors to say, we've got to go do something because we may be worried that the other tools that are supposed to be regulating doctors aren't doing their job. I just think, and again, not to speak for others, prosecutors are quick to think others aren't doing their job as an excuse to do their job maybe a little too well in some settings, and that's why this ultimately got to the Supreme Court.
Yeah, I'm going to jump in too, because I think it's really, really important to understand this doesn't allow them to escape liability. Like, it is likely that even if these convictions are overturned and they don't, serve any time, beyond this, they will never practice medicine again, right? There may be the basis for civil liability. Their entire professional and personal lives are likely in shambles, okay? But you made a comparison to somebody who's dealing heroin. This decision made Clarion that actually the standard for conviction is the same, meaning in both cases, the government must prove that the defendant knowingly or intentionally distributed a controlled substance. The circuit split leading up to this decision created a double standard. So somebody, sort of the conventional drug dealer distributing heroin had, the government had to prove knowing or intentional distribution of a controlled substance. But in the 10th, 11th, and arguably 4th Circuit, the government only needed to prove that a doctor departed from some general standard of national medical practice. They had transformed this into a strict liability offense. Okay. And so what we were pushing hard against was, you cannot criminalize negligent or mistake, or frankly, even sometimes appropriate medical care. This is a felony statute, and scienter, like the vicious will, is critically important in these cases. And by the way, knowledge intent is literally written into the statute, which is what the court picked up. But make no mistake, doctors aren't going to escape punishment. There are myriad ways for them to be punished. And the point is that criminal felony drug distribution should be reserved for those who truly are engaged in a criminal enterprise.
Thank you for that, Professor Gillespie. We only have a couple more minutes, and there is a question in the Q&A from a potential. Excited to see. So I'm gonna pose that. The question is, what do you think would change if start with Professor Berman and see if we have any real quick reflections on what Ruan might mean for the future of drug policy more generally.
And I think it's a great basic question I think we're having, and whether it's marijuana, whether it's psychedelics, you name it, a sort of broad rethinking about how we approach a range of drugs and drug policy in our country. I don't think Ruan directly will. I think Ruan provides another opportunity for us to think really hard, and especially Dr. Freed's experience is, reinforced. And I'll try to tee him up for this as well. Whereas, what would we think about a Dr. Ruan or a Dr. Khan saying, yeah, I know I wasn't doing this the traditional way, and that's why I was doing it, because fundamentally, I think our entire drug policy is messed up in that people who have gotten addicted to opioids or have other substance use issues can't go to their doctor and get a safe supply and get access and be monitored and be, in a sense, under care in the kind of way that that other kinds of persons with comparable diseases that aren't stigmatized quite the same way are able to get access. And so I think it's a wonderful question. Please come to law school, students, so you can ask that question more, would-be student, and just I think that's where this conversation for me is so exciting and so important. Is it's not just where does criminal law and medical practice kind of intersect, but in the broader policy space of drugs, what regulatory regimes sort of balance harms and provide benefits the best possible way. And I particularly feel us lawyers get to sit around and debate it. Doctors have to live it, and I would be eager to hear your take on it.
Yeah, I mean, I guess my reflection on the question is my addiction clinic and dealing with patients with complex pain, especially high dose opiates in uncomfortable circumstances, pushes me to be in this nebulous feeling this is I do get uncomfortable every once in a while, and I actually think that's okay. I think it's okay for us to be a little bit uncomfortable, and I do think that the kind of protection here is that I'm doing this in the service of my patient in the circumstances that are here. There are pieces of this that are far from ideal, but I think it's okay for us to practice in that space, and I hope that's a legacy of this case.
Well, I think we're out of, we're gonna get kicked out. I wish we could hear from Professor Oliva and thanking our fantastic panelists, and thanks.
Conversation we've just started, so look forward to talking with you all more about all these